I am the problem. You are the problem. We are all complicit in allowing a culture of violence to continue. Even if we are not the ones committing the assaults, we are the ones brushing off casual catcalls, unwanted touch on public transportation, groping, victim blaming, and revenge porn. Rape is on one end of the spectrum that describes all of the beliefs, behaviors, and attitudes that fall under rape culture. Until we address our culture's normalization of sexual violence, nothing will change. I remember sitting in the Suffolk County Superior Courthouse here in Boston in late June of last year. We had just been read yet another not guilty verdict in a rape case. The prosecutor that had been assigned to the case turned to me and admitted defeatedly, "I'm just struggling to know how to talk to the victim and explain to her that she's viewed as disposable in all of this." In the wake of the Me Too movement and highly publicized court proceedings of Harvey Weinstein and many others, it is clear that there remains a cultural and legal bias against survivors of sexual violence. Prosecutors and judges in recent years have fought for better protection of survivors. However, despite a shift towards anti-rape implementation and more progressive prosecution, my research over the last year and a half as part of my undergraduate thesis demonstrates otherwise, that legal outcomes have not meaningfully changed for survivors. Through a 4-month-long period of court observations and 25 in-depth interviews with police detectives, attorneys, and judges, I find that despite achievements such as the Violence Against Women Act and Rape Shield statutes, prosecutors continue to face juries and defense attorneys that believe in rape myths. I'd also like to note that in my data collection, all of the victims in the cases I observed were women. So this is not to say that these are the only victims that exist, but this is why I will be using gendered pronouns to refer to the victims as I give examples. In today's talk, I will outline the 3 main legal barriers I observe standing in the way of meaningful change. First, survivors are expected to behave in ways viewed typical of a real or legitimate victim in order to be believed by the system. Second, there's a very low bar for consent, meaning the legal system requires very little evidence to deem an encounter as consensual. And third, victims are set up to fail because the process of jury selection is biased against them. Then, once I've gone through all of these, I will outline how we can do better. So, let's dive into the first barrier, that survivors are expected to perform as the perfect victim in order to be believed. In other words, they are expected to conform to a list of criteria, for example, supposed sexual propriety or an immediate disclosure of their assault. Did you squeeze your legs closed to prevent the defendant from raping you? You say you screamed, but no one heard or came in response? You didn't call 911 or the police or anything? You didn't scream at the top of your lungs so that everyone in the building would hear you? These are examples of real-life questions I heard asked by defense attorneys to victims during cross-examination this past summer. What does it say that these are the first questions we ask of victims after they disclose an assault? Are we saying that coercing an individual into sex is okay if they didn't scream at the top of their lungs? I witnessed on multiple occasions defense attorneys ask the jury flat out, "Does that sound like a victim to you? Scared? Someone who's been raped?" In one case, the defense attorney went as far to call a witness to testify, saying that he had seen the victim laughing the morning after she'd alleged being assaulted. The attorney then referenced this moment in his closing argument, saying, "The victim claims the defendant raped her, but her actions you have heard are completely inconsistent with someone who claims to have been raped." Clearly, victims are expected to prove the severity of their assault at every turn. They are expected to have resisted perfectly or in as physically extreme a way as possible. The problem with this, though, is that perfect doesn't exist. There's always more a victim could have done or could have said to make their non-consent more clear. What this reveals is that the construction of perfect victimhood only serves to deny and undermine victims' real lived experiences. Let's dive into the second category, the low standard of consent. In another case I observed, the defense attorney countered the argument that the victim had been too drunk to consent to sex at the time of the assault by producing evidence that her eyes were open. Despite the fact that the victim was not moving and her blood alcohol content, or BAC, was over 3.5 times that of the legal driving limit at the time of the assault, the defense attorney mentioned 4 times that her eyes were open. This is a powerful example of how easily consent is presumed, even in cases where there's evidence of seemingly clear impairment. This shows how low the bar for consent really is when dealing with the legal system. I also witnessed on multiple occasions defense attorneys utilize semi-sexual behavior as evidence of the victim's assumed later consent to sex. In one case, the defense called the witness to testify, saying that she had seen the victim and defendant kissing earlier in the night prior to when she had alleged the assault. The defense attorney asked the witness, "So, there's a lot of kissing and hugging between the victim and the defendant, correct?" There was a lot of kissing on the cheek. The victim was kissing the defendant on the cheek throughout the night. Is that correct? The defense attorney here sought to imply that because the victim had apparently consented to these other behaviors earlier in the night, it's implausible that she would not have later consented to sex as well. Again, both examples make clear how low the bar for consent is. This practice overlooks crucial factors such as coercion, incapacitation, and even a lack of genuine willingness in validating survivors' experiences and perpetuating misconceptions about sexual autonomy. It also creates a culture where perpetrators can exploit ambiguity as a way to evade accountability for their actions. Again, are we saying that coercing an individual into sex is okay if at least they were not unconscious? Are we saying that consent to kissing and hugging is equivalent to consent to sex? The third barrier that I observed was the process of jury selection. After sitting in on the questioning and vetting of biased jurors in various cases, I was struck with an observation. I realized that the same questions meant to remove biased jurors from the pool were also effectively resulting in a jury pool not representative of the diversity in identities and lived experiences of the general population. I observed judges ask potential jurors the following questions. Have you or anyone close to you ever been sexually assaulted? Do you have any beliefs about rape or sexual assault that would prevent you from being a fair and impartial juror? Would you automatically be inclined to believe a child who comes forward with allegations of rape? If a potential juror answered any of these questions with the affirmative, they would immediately be excused from service. Research shows that over 50% of women and a third of men have experienced sexual violence at some point in their lifetimes. This doesn't include people who don't even fall into either of these categories. What this tells us is that not only are the courts pushing women out of juries, but also people with real lived experiences and exposure to sexual violence. These are arguably the people who are most informed about the behaviors and nuances of sexual violence cases, and therefore best equipped to counter victim blaming and rape myths in court. So, in a system, the legal system, that already tends to treat women and people who are not men as though they are lying, this practice stacks the deck in favor of the accused. So, what do we do with this information? I argue 3 things. First, we must recognize that sexual assault does not look one way, and there is not one victim of sexual assault. Queer and non-binary folks are some of the most at risk for being targets of sexual violence. Sex workers, particularly sex workers of color, trans sex workers, migrant sex workers, as well as people experiencing homelessness are also uniquely vulnerable. Our culture will not be just, equitable, or safe until even the most marginalized of our communities are protected and viewed as deserving of protection. No one should be expected to perform as the perfect victim in order to be believed. Number 2, we must come to terms with the fact that sexual assault is not the only problem. We must not brush off when people casually catcall or normalize violence in intimate relationships. We must keep an eye on our friends and loved ones in their relationships and know what to look for when something feels off. The same peers who would pull girls' hair on the playground and invade others' personal space without consequence are the ones who will grow up to feel entitled to people's bodies and assault those around us. Locker room talk and casual violence are the opposite of harmless. They're pervasive, easily overlooked, and we must stop disregarding them. And third, we must stop turning to the legal system as our only mechanism of justice. My research shows that even in a progressive setting, Massachusetts, the legal system is still not able to effectively handle cases related to sexual violence. What this tells us is that the legal system is simply not designed to deliver justice in any context. Let's invest in prevention by funding education, healthcare, social housing, and non-police crisis teams. Sending people to prison achieves nothing. It doesn't stop the violence, it doesn't make our communities safer, and it doesn't erase survivors' trauma after an assault. In an interview I conducted with a law professor, I asked if he had any final words of wisdom to share. What he told me still replays in my mind. He said, and I quote, "The longer I've taught this material, the more I've become convinced that the legal system is not set up to deliver the kind of genuine accountability that would actually reduce the incidence of sexual violence. The system does not care about victims. Therefore, why would victims willingly undergo a system in which they become tools to people who are not invested in their healing or closure? This system is simply not able to deal with this particular kind of offense in any meaningful way. So, until we reconceptualize how it works at large, it will not be serving people's needs," end quote. So, today, I ask you to envision a world where the legal system is not our only vehicle of healing, restoration, closure, and justice. What would that look like to you? Thank you.